Good afternoon, everyone. I'm Jean-François Lapointe, Advisor, Development and Training at the Limoilou Cégep. Today, for a first, I would say that we have with us two outstanding people from the construction world. They will join us to talk to us about the BIM approach. Obviously, the legal aspect of BIM is a very important issue. Mr. Yvan Houle, here to my right, and Mr. Quinn at his side. They're both ambassadors and advocates of the process. They will share with us their expertise on the topic. Mr. Houle is associate at BMG. He's recognized as a very expert lawyer in the field, and Mr. Houle uses his experience to help in terms of procurement and call for tender, bargaining for contract, and resolution of disputes for a whole slew of situations. Mr. Quinn, Principal Associate of Martin Rose and Fulbright, he pleaded in front of all these civil instances, and he was called upon to write up business contracts, provide professional services, as well as documents, call for tender documents. He's also a recognized expert in the law for construction. He's mentioned in many documents and many publications. Thank you very much, both of you, to be here with us. First of all, the way it will work. I will invite both panelists to make a brief presentation, and then we will go to an exchange on various legal topics. Obviously, we will reserve some time for questions from the audience. I imagine that this sector will trigger a lot of questions. So without further ado, panelists, we know that 5 years ago, the mixture of BIM and the Quebec and Canadian law concerned people. How were we able to adapt to this BIM shift, and what are the alternatives? So, Mr. Houle. Thank you, Jean-François. I found the previous presentation very interesting because it shows the courage and the vision that the players have. With hindsight, now that when we think about where you were in 2011, 2012, some players decided to adopt BIM. And I would say that we, the lawyers, in our field, legal field, were recognized as being reticent. So the easiest answer for lawyers to say to our client, no, it's impossible, it cannot be done. But the interest of BIM for me as a practitioner in the field of construction is that it pushes the lawyers to follow the rhythm of or the advances of technology and try to find innovative solution within the legal framework that exists that do not necessarily follow. We have a lot of catching up to do. This being said, one of the tools that is available, we see that there were a lot of changes in the legal field. Some organizations were set up to favor the legal supervision, amongst others, of this modeling system. One of these organizations is the Institute for Modeling the Data, the IBC. It was founded by various players of the industry. It is a group of a whole plethora of the representatives of the industry. We have architects that are present, engineers, the Canadian Association of Construction that represents mainly the general contractor, and Plans and Specs Canada. There's Defense Canada that's very present within IBC. This very diversified representation allows us to hear the various perspectives concerning the issues and problems that the players identified. And based on that, trying to find a compromise or beacons that will assist all the players of the industry to make the BIM advance or progress. The mission of the Institute is very simple. It fostered the coordinate use of these functions are on two levels, mainly. There's an education and training function that was developed, and also the promotion of a contract framework that can be used for upcoming projects. Concerning this, IBC developed standardized documents, IBC 100, 214. It's an annex to the IBC contracts. So it's an annex or a schedule that is with the normalized contracts, contract of the general entrepreneur, general contractor, and engineers to meet the needs of a project that will be carried out in BIM mode. The second document that deals with the level of development and the authorized use, the authorized use of new developments and the table of the development model of the various models. So this annex favors the use of a common terminology. So obviously, the assumption is that all the stakeholders will buy in this annex, and it fosters the use of a protocol that is not really prescriptive because the players identify their needs according to their project, and it will help to develop the way the models will be developed, what elements will be retained, and how the players will interact with the models. Obviously, some statements, some obligations are explicitly recognized by this appendix, by this contract. So first of all, the parties convened that this appendix, so all the players accept that they will use BIM and that the content of the model will be shared. And finally, it allows a member of the team, a participant to the project, to obtain the confirmation that someone will ask for the transition of the model. The objective here is to make sure that all the stakeholders taking part in the project fully know what they subscribe to.
Un autre enjeu qui est très important dans le monde du BIM.
Something else that's very important for BIM and for professionals is property rights or copyright. So the appendix, as written up right down, retains the copyright that flow out from the comments of the various stakeholders, be it the contractors, engineers, or architects. Another important element, and there's no cession of the right to use for the future. We know that in the field of construction, the use of a model by an owner, for example, on another project, once the model is well established, can the owner simply take it and use it and reuse it? In this particular case, there is a ban on this. Doesn't make that the parties won't be able to agree on this, but according to the existing model, is that there's a ban on reusing the model. There's also a whole series of clauses dealing with the notion of responsibility. Essentially, what we're aiming at is to exclude the responsibility of the stakeholders when there is a bad use or a non-authorized use of the model. So there are protections that are included in this appendix, namely to relieve the fears that the various stakeholders can have concerning this unauthorized use. And finally, concerning this appendix and new developments, we see that the proposed annex includes 5 levels of development. It goes from the very general to the most developed. There's a table of the elements that's quite detailed, and it depends on and goes back to the elements of a standardized or a standard specs, and it allows to determine who has the responsibility to modelize this particular element. And there is a certain level of specification that has to be met here. So thank you very much, Maître Houle. So these are documents that did not exist. Well, these documents are very recent. 2 years? Almost 4 years. So these documents did not exist 5 years ago, so it's a real revolution. So I'll leave the floor to Mr. Quinn. And thank you, Jean-François, and thank you very much, BIM, who invited me today to make this presentation. We would need some training here.
Okay. Bon. Alors, bonjour.
Good afternoon. There we are.
C'est beau, page 6. Merci. Daniel, Monsieur Forg mentionnait ce matin.
Monsieur Forg this morning talked about all that has been done, and in all the excellent presentations we heard this morning and at the beginning of the afternoon, it was very telling, these few words.
En matière de BIM, ou disons.
What was done over the last 8 or 10 years involving BIM in Quebec, including the legal aspect. Well, 10 years ago, the BIM as a legal entity outside Quebec and outside Canada was really real. We had players here, companies such as Canam and Pomerleau and others, who already had been using BIM for many years in very sophisticated projects. I remember having attended a conference where I heard a presentation about the Center of Luggage Handling in Hong Kong. Canam was involved in this project many, many years ago. So it's clear that this company participated in this BIM reality abroad, but not here in Quebec. Since then, a lot was done. Everything we heard today is very telling concerning this. We just heard about the Montreal Airport project. We heard about the Olympic Tower. Many other projects were mentioned, the Quebec Airport as well. And we see to what extent BIM progresses. And in the medium and long term, it will probably involve the life cycle of the building until its replacement or demolition. On the legal side, we have a lot of catching up to do. Nevertheless, 6 or 7 years ago, nothing was done. There was nothing. It was a great vacuum. There was nothing written in Quebec for BIM. Nothing was done, and there was a very bad comprehension from the legal point of view of this BIM approach. Progressively, we went from the vacuant to a prepared land with all the services, the road network, the services, electricity, etc.
Alors aujourd'hui, d'un point de vue juridique,
today, from a legal point of view, we are on a land that is evolving and that is ready to receive a whole city of BIM use. Amongst the most important elements that made this land constructible or ready to receive buildings, obviously, there is the accuracy of the terminology that flows from the IBC Bendix. that gives the standard conditions of ASCII, many contracts or contract requirements that were published in the very recent calls for tender. Obviously, there is also the training that is given under contract by the Limoilou Cégep, Vieux-Montréal Cégep, and the documents, Module 3 that they published. It's a very, very good document, as good as any other document for the training from a legal point of view. Players, BIM players, really have to refer to this document that is a high-quality document. So we can create now a legal terminology, lingua franca, if I may, on the determination of a whole slew of needs from a legal point of view that have to be met when the contracts are written up and when the use of BIM is considered for a specific project. There are also the digital signing that is made possible by Notarius and the Ordre des Architectes du Québec. There are the best practices and the conventions concerning the storage of the model, and all the publications, the training that's given by CAN-BIM, by the research chairs of university, days like today. So nowadays, from a legal point of view, to close the loop, there is a very widespread and documented comprehension based on a whole slew of documents that are there, that are available, and that allow the players on the market, when they want to put in place a BIM process, to legally supervise it in a precise way, in an informed way, and in a refined way. This was not possible 10 years ago. Let's remember major projects that were launched with the only requirement from the BIM legal. The project will be built for this project, or BIM will be used for this project. One line for a major project. Nowadays, nobody would think of using BIM with so little legal supervision. And the tool I mentioned, and Yvan referred to it, the one published by the Institute of BIM of Canada, which allows to define the authorized usage, the schedules for the various deliverables, etc. So that, assisted by this lingua franca, by this group of tools, we can integrate as it's possible, and as you do from a technological point of view, you can refer to the best world practices. We can also integrate or refer to the best legal practice. There is no contract definition that the market cannot absorb. So much so that if the players want to devote time to it and they want to define this contract supervision for a given contract, there are tools I mentioned and even more. Namely, a standard contract published by the World Institute of Architects. All this can be integrated for a given project. So common terminology, determination of the needs, and there's a lot of documents for all this. Last comment before going on with some other issues and questions from the audience. Also, as far as BIM is concerned, we have to remember two major principles, BIM principles. So there's a section 1434. So the contract involves two parties. So what does that mean if we're talking of BIM? It means that the owner and his consultant can consider using BIM, but if you forget to involve the contractor in the BIM protocol or in the BIM convention, there will be a gap. Something will not work. All the stakeholders, down to the supplier, the subcontractor, have to be involved. in the definition, or at least they have to accept the definition of the authorized usages or non-authorized usage of the model. Who will have the role of designer and for what objectives? Each designer will have a specific role, and this has to be planned for in the BIM appendix or BIM contract or BIM protocol, whatever name you use. And if it's not planned for, if the stakeholders in the project do not take part in the writing up of this protocol, they won't be bound by this, which lead us to the public order contract that applies to this. And this framework, well, I would like to come back to the first question posed by Jean-François. When we talk about the code, building code, security code, the law on engineers, the law on architects, Civil Code of Quebec, this particular framework was not modified at all over the last 10 years to reflect the BIM reality. The deontological responsibilities of the engineers and architects are still the same. So if we do not adapt and adjust the requirements and the possibility to use the model for such a purpose and not another one, then there might be inconsistencies between the end work of the engineer and the architect and what this finality should accept. A safe building that meets the safety requirements for which it was built. So these fundamental responsibilities are the basis of all of our law in terms of construction. And a model, the uses of which will not have been circumscribed specifically, authorized or unauthorized uses, the identification of the authors for the various input of the model. These were my preliminary comments. Jean-François?
Merci, Maître.
Thank you very much, Mr. Quinn. First of all, I'm very happy to hear that there are now available tools that foster the usage of BIM. It was possible to use this tool before, but there were much less tools. What I understand here, that it's not, the legal framework is not presently a real obstacle to use the BIM process. Is that it? I think you're right. I think that what you said is fair, but as we both underscored, this legal framework has to be adapted so that it matches the BIM requirements. And for a lawyer that practices in the field, this is what's interesting in this field. It forces us, it forces the owners, the contractors, the customers. It forces us to adopt a different thinking, to think outside the box, and to try and being innovative. Innovative. Now, the quid pro quo is that there were very few disputes involving the use of BIM because the courts have to be trained also to solve these disputes. Maybe I'm generalizing here. Some judges are quite old and they don't know this BIM process. It will be interesting to see how they will react facing such disputes. Two comments. So the courts, and I would like to refer you to the other section, 1434, the courts will interpret the contract of a given situation, referring namely to the use and the practices. Training, such as those provided Module 3, that is provided or given at the Montreal Cégep and Limoilou Cégep, it's part of a mode of understanding BIM. Such a document could very well be presented to a decision maker, a judge. Well, here you are to help you understand the BIM. This is a pedagogical tool that is very useful and adapted to the Quebec legal reality, and you can use it. You're now telling us that Cégep will be able to train judges on BIM. Yes, in fact, as we have to explain structural problems to judges, is the same thing for BIM. We have to train them, in fact, because BIM is a technological approach, but we should have a training course, a training manual to help judges better understand this approach. Yvan mentioned it. I would like to come back to what Yvan said. Nobody in the room here, because I see only very, expert people here. In fact, those I know and those I met very recently. None of you would think of telling a customer, you have a project? I have a very good contract for you. I executed a project 4 years ago. I have a very good contract for you, and you give them a voluminous document, and the customer will say, well, what about the stakeholders? What about the advisors, external advisors, in-house advisors? My strength, technical strength, they're not the same. This contract has to be adapted to my requirements. It's the same thing for the BIM appendix. In all cases, without exception, it has to be adapted to the needs of the stakeholders, adapted to their resources, it has to be adapted to the owner, who has 4 BIM specialists in his team. This morning, for example, Mr. Leduc from the Quebec airport mentioned that there was a specialist in-house that that followed the coordination. So there has to be consultants, subcontractors, etc. Some owners don't need all these specialists because many functions were already integrated. A contract, yes, but Jean-François, to answer your question, obviously the law 10 years ago would have been an obstacle to the use of BIM because there was a lack of lingua franca, of common terminology. And even for the most sophisticated project, in no way in Quebec, the law will be an obstacle to the use of BIM. However, and I'm being a little facetious here, I made a verification in the Azimut database on my computer to see whether BIM is mentioned. I'm sure that 12 months or 24 months ago, no mention was made of BIM, but I checked a few days ago, I found about 10 rulings, cases, where I said Mr. Dagenet was advancing on a project. He had 2 BIM on the shoulders. So for the time being, BIM is spelled not B-E-A-M like a beam, but it's spelled B-I-M-E. But in Quebec, I excluded here arbitration because the arbitration rulings are confidential. So there is no cases that dealt with BIM. It reassures me.
And that's exactly what I retained from the conference where I was recently. Well, time is flying by. I have a few questions that I'd like to ask you. And you'll confirm whether or not, but they might be wrong beliefs or wrong perception about the risk involved. A lot of people, when they talk about BIM, say that BIM is riskier, BIM increases my liability. So I'd like to hear you speak to that. Is this true? And why is it that people believe that? Well, I can tell you that the first time when I worked with a BIM project, what you've just expressed is exactly what we heard without any doubt, and we still hear it frequently. My response to that is that BIM, as we've seen it, fosters collaboration between different stakeholders, always with the hope that the project will be completed on time, on budget, without any claims or fewer claims afterwards, which might not be as good for lawyers, but I think that it does reflect how the law has evolved. Because over the past few years in case law, the courts recognized, specifically when it came to the major construction projects, that it was important and necessary for the various stakeholders to collaborate. And to the extent that BIM fosters this collaboration, it has only reflected what case law has shown us. So to that extent, the risk or the liability is absolutely aligned on what is seen now in case law and jurisprudence. That's a very good comment. In fact, it's true that there is a link with the obligation to collaborate. This was defined and specifically framed in 3 recent rulings by the Court of Appeal over the last 3 years. John Murphy published in the Journal of Canadian College of Construction Lawyers an excellent, well-researched article. It's almost a master's thesis on the obligation to collaborate in construction law. That is, any professional in construction should read this. And there's an example, and I was saying that to people, to the Pomerleau people around the table this morning, is that's an example of how it is possible to solve this problem with this curtain wall, is that you brought 20 people around the table. For a litigation lawyer such as myself about 15, 20, 25 years ago, this kind of situation would have given rise to a gigantic lawsuit. It would have been tens of thousands of dollars, some $60,000 possibly, and would have lasted less than 10, 20 years. But this possibility of a dispute with these kinds of difficulties arising has been eliminated and has been offset by the intensive work of collaboration done within the spirit of the current law, which provides for the requirement to collaborate. And again, then you're able to focus on staying on schedule and on overcoming some very important technical problems. And congratulations, because when it comes to fulfilling the obligations as respecting the client's needs, I think that we've really been on target. Could it be said that fostering exchange, that's the BIM effect. It fosters collaboration so that the effect might be to reduce risk. Yes, certainly it's going to reduce risk when it's a good BIM project, it's well managed. But there is one certainty, that a catastrophic project we don't need BIM to see any of such catastrophic projects. I've had dozens of years of practice, and there will be disastrous projects, and no doubt there will be further terrible projects carried out, realized with BIM. So if people don't have the qualifications, there will be disasters, whether it is with or without BIM. But generally speaking, I think that Mr. Leduc's presentation and the numbers that he cited this morning are very telling. Because, generally speaking, a well-managed BIM with the proper focus, with the right teams, is going to reduce the number of changes made, will make it easier to process change or interference or other things. So no doubt it is a benefit. It will lessen the number of possible litigations. Could we move on to another point? Yes, I have another question, but I'll let you finish. In the area of risk, and I'm just dovetailing on that. So when it comes to risk, possibly the greatest source of risk in BIM is that we're working in a real time, that a number of parties are working together rather than doing it sequentially. Mr. S.R.L was referring to this. So we don't first have plans sent from one to another, then we have one set, another set of plans, and then we have the final ones for construction. So there's exchange throughout the construction phase with all of the parties. But at the end of the day, you have the 2D plans in Quebec for the time being. That's the case here, except for Hydro-Quebec. That's exceptional. They've been able to do these digital plans, but generally it's 2D plans for construction. And these plans have to be signed and have to be issued by somebody, again, based on a model which mostly is mandatory. Sometimes it's voluntary, but usually when it's mandatory, these plans can be matched with the relevant part of or the whole model. And the BIM risk, perhaps the biggest risk, is that what comes into this architecture plan or the mechanics or electrical plan or the drawings is that what is entered there is not always being controlled by the author. So if you integrate, let's say, suppliers, mechanical manufacturers, if you have data on, for example, equipment for production, you involve loads or structural elements, these are not checked, then the risk is that the equipment provider who's supplying data that's now integrated into the model and who then receives drawings, will this equipment supplier become a designer legally? That's a question we can ask. Perhaps he has the necessary license, perhaps not. Is he a project designer or not? So there are all kinds of issues that arise out of the sharing of an integration of data, because you have a second designer, a second player that comes in, and perhaps a third party will entrust the architecture or structural mechanical parts of the model. And that really is at the crux of the main difficulties we have. They're manageable, but those are the main problems of the BIM. So it's a matter of traceability, isn't it? The idea is to trace back everything that's being done as you move along. Because that was one of my questions that I had about the trends we can expect over the coming years. The more we tend to see these trends in isolated types of models that are then federated. So there is traceability, but if we're to look forward over the coming years, where everybody be working in real time in various offices on ongoing design, that's where we might see problems legally, because we're going to lose that traceability. Is that what you're saying? Well, without any doubt, that's going to be a challenge, because the traditional model of involving a construction dispute is really at the heart of the matter of attorneys, is that you have to prove that damages were caused, and that's part of what you're then claiming. But as soon as you loom traceability of the stakeholders or everything that comes in, like Bernard said, everything that was contributed to this model, that might give rise to problems in identifying liability. What we hope to see is that by managing our BIM model reasonably, we should not end up there. Nevertheless, if the project should run into problems, it's an issue that we sitting here today, we can't really give an answer to in light of the current civil code we have and the elements of evidence we have. So those are the limits today, right? We mustn't cross that line. Is that correct? Yes. So we have very little time left. Things are going very, very quickly. And I'm sure that Jerry would be extremely pleased to give us more time if we weren't a little bit behind in our agenda. So I'd like to hear the participants speak to this. No doubt you have some questions. So we can take 2 questions from the floor about the legal aspects. Unfortunately, we can't hear you without a microphone.
Alors, voilà, j'avais une question pour vous, justement, dans l'obligation de...
I have a question about this obligation to collaborate. Unfortunately, the interpreter is not getting a feed and cannot hear the question. Very sorry.
À la qualité de la collaboration et du travail collaboratif, c'est-à-dire que les donneurs d'ouvrage disent, ben, écoutez, utilisez la plateforme BIM, la conception intégrée, puis voici votre obligation relationnelle, puis si vous atteignez des performances au niveau de coût, délai...
Inaudible for the interpreter.
Est-ce que ça, c'est une pratique ça me semblait être une pratique qui est à développer au niveau juridique, c'est ce que j'avais vu là-dessus.
Ben, je peux vous dire que...
Well, this is not something that ever came up on my desk up until now. I think it's a good idea. No doubt, this is a very avant-garde client who would have included that into an estimate. But that would be a good thing, because it simply reinforces the message we've conveyed. It ensures that the stakeholders are completely aware of their obligations, specifically when it comes to collaboration. I saw that in the UK. The government had put in place these kinds of contract formulas to make sure that everybody can benefit from him. Yes, we can certainly build on that legally. I think there's something we could do with that. Yes, it could be used as an incentive. Well, with a good team, with the right context, we need a capable team to start. I think there would be a good incentive, maybe less so with a team that has a steep learning curve to climb up. Well, I think that would be connected to obligation to reach the second level of competency. Are there any other questions from the floor? Amin Hamad, University Concordia. Do you have accurate definitions on developing 4D models? Well, there are for development, but as recognized and acknowledged by the industry, well, they're currently being defined at this time. 4D is still quite new, and it's still really on the avant-garde. Well, when it comes to models, this is never mandatory. These are models published by organizations or groups of organizations who've been working together, so they don't have force of law. But as to the AIA and the consensus docs in the United States, there are some very detailed definitions which could no doubt be used to develop or adapt a definition that would be appropriate for a project. At least that would be my viewpoint. So first of all, for something that is already very developed and detailed, a consensus doc was an option. And the last question. How important do you find the Patriot Act is when it comes to these BIM projects? Projects that might take place in the cloud. Pardon? In the cloud. They might take place in the cloud. Well, I think that we're moving beyond the purview of my expertise, but I have worked on a number of cross-border projects, and I do know that this might be an issue because depending on the sector you're dealing with, for example, in the defense industry, just to cite an example, or aeronautics, data transfer between the United States and Canada, just to come back to the Patriot Act, well, there are certain restrictions in place. I think the provisions of the Patriot Act will apply to a BIM project, something that's being developed in the cloud where there are certainly cross-border aspects to take into account. But to what extent this is applicable, I think you'd have to turn that question over to an expert on the Patriot Act. I have a challenge for you, gentlemen. We've got 2 minutes left. Can I ask you another question? If not, I think we can open up the debate for the next times. What about copyright? Maybe we could conclude on that note. There's some concerns with copyright when it comes to the digital model. Are these well-founded concerns? Is there a true danger that copyright might be lost? I'd say that this is a very legitimate and important concern. The designers, the stakeholders who work on developing a model don't want, at least I haven't met one yet who has a different viewpoint, they don't want that model or parts of that model to be reused for other projects without them benefiting from them and without them having approved this reuse of it. So very briefly, and I'll turn it over to Yvan after, there are 3 means that they have available to them to frame this. First of all, to ban it. Secondly, allow it, but subject to approval, to consent. That is, they need to obtain written consent when their use or reuse is being considered, and the stakeholder who hypothetically does not actually take part in the project where the model is being reused. And this has to be associated with some kind of compensation or a grid for compensation, some kind of scale that's provided, that in the case of a dispute, there's a calculation, there's some kind of compensation scale which allows for the reuse, which in any case won't be comprehensive because the actor who's not taking part will certainly not sign off on a huge project, but his intellectual property would be incorporated into a complete model and will then be reused. Usually, banning it is the best remedy, but there are other means of managing this. And more specifically, depending on the documents you have, depending on the literature, is that when you have parties who usually work together, but they don't always work on in the same team, there it's possible. So I'm very sorry. May I just answer very quickly? When I talked about the schedule, the appendix, there you could adopt this model for banning. And you understand that as part of the list of stakeholders who are part of the IBC. There were professionals who did the best in negotiating this, although I recognizing, like Bernard said, that it's possible for the parties to amend this part of the contract regarding the model. But for the purposes of the appendix, the banning is currently in effect. 10 seconds. Obviously, when you're talking about reuse, you always need a bit more. Yes, that's for the service life of the building. Obviously, that's considered, that's possible, it's allowed. But when we're talking about reuse, that has nothing to do with the actual service life of the building. I don't have to raise an objection here, do I? To stop you. Thank you very much, gentlemen. That was extremely interesting. I think that we could have talked about this subject for hours and hours.